do that now because I tend to forget that part. So welcome everyone. This is our second family forum for 2022. Good to see everybody here and online. Appreciate you guys joining us. We do have a great topic tonight, estate planning and stable accounts. And with us, we have David Banas. He's an attorney with Hickman and Louder. And we also have Doug Jackson, who is Deputy Director of Stable Accounts with the State Treasurer's Office. So this is a really good presentation. It's a good one to go back to our website afterwards if you want to re-listen to it. That's why we have that recording for you. And we will also post the presentations, and in the case of the stable accounts, the actual link to stable accounts website for their presentation. And I think that's it for now. So I'm gonna, David, if you want to go ahead and take control.
Sure.
And I will continue to monitor the chat box. Anybody online, please make sure that you're muted so we don't have the background noise. And if you have a question, go ahead and put that in the chat box and I'll keep an eye on that. Okay. All right. Thank you.
All right. Well, thank you, Jody. Again, my name is Dave Banas. I'm with the law firm of Hickman and Louder. And tonight I'm going to kick things off by talking about all things special needs planning. We're going to do some basics of the benefits, trusts. I'll briefly touch on stable accounts, kind of how they fit into the plan as another tool in the toolbox. And then I'll briefly touch on what you need to know about guardianships and, you know, if they're necessary and how they work and things like that. So I assume there's going to be a lot of questions. I'm going to zip through my PowerPoint here, you know, do my talk. And then at the end of my PowerPoint, I will be available, I guess, for questions. If we want to go right into Doug, we can do that. It's up to Jody, I suppose. But there will be questions, and I encourage everybody to ask questions, and we'll get those answered. So to start things off, I mean, what benefits are involved when we're talking about an individual that has any form of special needs? We have SSI, SSD, and SS. So SSI is supplemental security income. That right now is $841 per month. That's the maximum you can get. That's a means tested benefit, meaning you can't have more than $2,000 in assets that are countable, and you can't have income without it offsetting that amount that you receive. Social Security basically provides an income stipend for an individual that doesn't have a work history of their own to draw upon in early retirement. That's sort of like Social Security disability. And it's really intended to be used for food and for shelter. Food and shelter, you know, the $841 a month is clearly not enough to cover almost anybody's food and shelter for a month. But that's what it's involving. And if you're receiving food or shelter from another source, they call that in-kind support and maintenance, and that will be deducted. A portion of that at least would be deducted off of the SSI benefit. And I'll talk a little bit more about that as we go along here. Social Security disability, SSD, is what I like to call that. It's early retirement. An individual is disabled. They've paid into the system themselves, and they're able to, because of their disability, access their Social Security benefit as if they were retired. It's early retirement based on disability. And if there's an individual that's been determined disabled by the age of 22 by the Social Security Administration, and then their parent retires, they can be what's called a disabled adult child and receive Social Security disability based on their parents' work earnings. And again, I'll get into that. For health insurance, we have Medicaid, Medicare, and private insurance. Medicaid is always the payer of last resort, and it provides services through the waiver programs that are not covered under Medicare or private insurance. An individual oftentimes can have Medicaid and Medicare, and some individuals have all three: private insurance, Medicare, and Medicaid, for instance. That's a possibility. We're also talking about, in some cases, food stamps, food assistance, and then sometimes subsidized housing. These are all means tested benefits again, and we have in all caps verify. And what we mean by that is before you talk to a lawyer like me about these benefits, or somebody at the county board, or an individual maybe in Doug's capacity or with the stable accounts, it's really important that you know exactly what benefits you're getting, SSI versus SSDI, or maybe both, and how those are being received. This simple diagram is, kind of describes the relationship between these programs. And on the top, you have SSI, Supplemental Security Income, and Medicaid. Those two are linked, and they're on the top there because they both are the means tested benefits. You can't have, again, more than $2,000 in countable resources. Your income is considered for both of these benefits. As opposed to the Social Security, Disability, and Medicare on the bottom. Those are more like entitlements. And again, if you qualify for Social Security Disability, it's because you're using or benefiting from payment into the Social Security system at some time, either in your own past or your parents' past. And along with that as well comes Medicare. And again, you can have Social Security Disability and Medicare and not worry about how much is in your bank account. But most folks who have Medicare and Social Security Disability are still going to rely on Medicaid, again, perhaps for a waiver or for premium assistance or whatever that case may be. And so you still need to almost always keep in mind that there's a $2,000 asset threshold in order to keep that. So again, and I'm going to repeat myself a lot, I kind of do that on purpose. Social Security Disability and Medicare are not means need-based benefits. They're not means tested. So the receipt of funds will not affect those benefits. If an individual on these two gets an inheritance or wins the lottery, kind of a silly example, but it happens, comes into money of their own, it's not going to impact your Social Security Disability or your Medicare. Once you have those, it's difficult to lose those unless the individual starts to work more and it is determined to be not disabled by Social Security. But again, like I said before, you still want to determine if other needs-based benefits like Medicaid are needed now or maybe needed in the future. And that's again when we turn to the means tested benefits, the need-based benefits of SSI and Medicaid. The magic number here is $2,000. You can't have more than $2,000 in your own name that are countable. There are all kinds of different non-countable or exempt assets. But if you have more than $2,000 in your bank account from 1 month to the next, you're going to risk losing your SSI and your Medicaid. Again, they also take into account your income levels. And so if you're earning income, if you're working, you have to report that to SSI and they will adjust your SSI amount accordingly. And then the last bullet here is it talks about deeming. Now, usually until a person turns 18 years old, mom or dad or both of their income and their assets are deemed to be the minor child's assets. That's why most of the time an individual under the age of 18 does not qualify for SSI. They may qualify through Medicaid through a waiver, the DD board waivers. One of the reasons why they're called a waiver is because they waive that deeming requirement. In any event, when an individual turns 18, that deeming stops, and that's most of the time when an individual will apply for Medicaid and apply for SSI, because they're no longer taking a look at mom and dad's assets and income. They're just looking at the individuals. That $2,000 asset threshold is sort of a hard line, but there are things that don't count towards it. One of the most important and common questions I get is, what about all the stuff the individual owns? Household goods, TVs, beds, household goods and furnishings do not count towards that $2,000 asset threshold. Also, the residence. An individual is permitted to own a residence in their own name. Same thing with a vehicle. An irrevocable funeral contract is also an exempt asset. So even if it's worth $8,000 or $10,000, as long as it's irrevocable, A prepaid burial and funeral arrangement is not counted on that $2,000. Life insurance. So if you have a life insurance policy with a total face value of less than $2,000, that's also exempt. And then the last thing is sort of the linchpin of special needs planning. And these are the special needs trusts, the exempt trusts. And there's a number of different types. And I'll go through those in a little while. So I think it's helpful to kind of go through a typical timeline for a child with a disability. Many of you have been through this already, and this is a little bit of review, but it kind of, I think, kind of incorporates how these benefits come available, when they come available, and how they're useful. And so, as I stated before, from birth until about the age of 18, there's usually minimal benefits because of that deeming that I talked about earlier, unless, of course, you're a low-income family or you have a child on the Medicaid waiver program. So if you have one of the waivers, again, they waive that deeming, and an individual can have Medicaid along with the waiver. But typically, an individual is not going to have too many benefits like Medicaid or SSI until they turn 18. At age 18, again, parents' income and assets are no longer deemed to the child. And that's when SSI and Medicaid eligibility become available, as long as the individual meets the income and the resource requirements. And so a lot of times if a client has a child that's going to turn 18, they'll come to me and say, well, we want to apply for SSI. At that time, we want to make sure that their bank accounts, their savings, maybe they have some savings bonds, that all of that doesn't exceed $2,000. And then you can apply and get your SSI. If you qualify for 1 cent of SSI, you automatically qualify for Medicaid because they have the same eligibility requirements, income and resource requirements. Even if an individual is working part-time, and they've been, again, paying their Social Security taxes, paying into the system, they may be eligible to receive Social Security based on their own earnings. And that's, I wouldn't call that common. But it does occur if they've been working, if they're 22 or 23 years old, and they've been paying into the system. They may develop enough quarters and enough payment into the system that their disability allows them to essentially tap into that payment into the Social Security Administration system to take sort of early retirement. And if you get Social Security disability, it's likely going to be more than the $841 SSI threshold. But then 2 years after you get your first Social Security disability check, you'll get your Medicare card. And that comes, it should come automatically, but it's important to know that that's 2 years after an individual receives their first Social Security disability check. Same would go for if parent retires or parent passes away. As long as the individual was disabled prior to the age of 22, when the parent retires or becomes disabled themselves, the child would become eligible for disabled adult child benefits, and that is calculated at 1/2 of whatever the parent receives. It's not that the child gets 1/2 of the parents, like they're not taking away from the parent's benefit, but the calculated amount is 1/2 of what parent receives. And then when the parent passes away, that 1/2 goes up to 75% or 3/4. And again, after 2 years of receiving those Social Security disability benefits, you have Medicare eligibility. So I've stated before, SSI is right now at $841 a month. It goes up every year as a cost of living increase according to the government's guidelines. Again, that's intended to be used for food and for shelter. And then along with that eligibility for SSI, you get Medicaid. Medicaid, again, the health insurance, the payer of last resort, pays for medical and hospital care, prescriptions, very basic dental and vision, and then it could pay for some residential or institutional care. Excuse me. And then the waivers will allow up to $14,000 per month to pay for certain services, goods, things that are needed, depending on the various waiver, depending on the level of care and how you're enrolled. And the folks at the DD board are the experts at how those are administered and what you would qualify for in those. So to get into the special needs trust, there are two types of special needs trusts. Non-countable assets, that means money in there isn't going to count again against that $2,000 asset threshold. And they're really distinguished by who owned the assets that are going into the trust. So there's a third-party discretionary trust that is funded with funds that have never belonged to the individual. So that'd be mom and dad's money through an inheritance or through a gift during life, or from anybody else for that matter, grandma, grandpa, aunts, uncles, siblings, whatever the case may be. Those go into a third-party discretionary trust. And since the money has never belonged to the beneficiary of this trust, there doesn't have to be a Medicaid payback. And that's a big distinction here. If there is money that the individual owns, if they inherit $100,000, or again, something silly like they win the lottery, or there's just accumulated assets over time, the money that's belonged to the beneficiary must go into what's called a self-settled special needs trust or a Medicaid payback trust. And the compromise that the government kind of made was, if you have assets, but you need to qualify for Medicaid, you can put those in a trust, and those funds can be saved and then used for whatever the beneficiary may need over the course of their lifetime. But if the beneficiary passes away and there's money remaining, it's going to go back to the state of Ohio or any other state that has provided Medicaid benefits for the beneficiary as a reimbursement. Okay. I want to check this chat here. Let's see. Okay, it's a question. So I'll try to get to the questions when I'm done. We'll kind of go through. Again, the self-settled trusts, the ones that are funded with assets that have belonged to the beneficiary, must have a Medicaid payback provision. And that again is any money remaining after the beneficiary passes away must go to reimburse the state of Ohio or any other state for that matter. For the most part, administration of a third-party trust and a self-settled special needs trust or a Medicaid payback trust are exactly the same. The money must be used solely for the benefit of the beneficiary. It can't be used for anybody else. You know, obviously, no one is an expert of how to be a trustee of this. That's why there are people like me in this world to counsel people through what needs to be done if you're making distributions, how to make distributions, what you can use them for, tax issues and things like that. More on the third-party trust. This is a trust that's been codified in Ohio law. The code section that talks about the third-party trust is much more restrictive than the SSI requirements. Remember, if you take anything away about third-party trust, it must be funded with assets which never belonged to the disabled beneficiary. So if your son or daughter gets a big graduation gift or something like that from grandma, and that's a check written out to them, you can't turn around and deposit that check into a third-party special needs trust. That would have to go into a Medicaid payback trust because that money was written out to them. Instead, grandma, in that case, would write a check directly to the third-party trust. If there is a third-party trust, and I don't see this as much anymore, but earlier in my career, I would see older trusts that allowed the trustee to pay for medical care, comfort, maintenance, health, welfare, or general well-being. That was sort of standard trust language a long time ago. That would be a problem. That would be a considered accountable asset. And so now our third-party trusts are really broad, and they grant the trustee with sole, absolute, and uncontrolled discretion to make distributions for the beneficiary. And that's it. That's all that the trust really can say. And so that leaves a lot of trust in your trustee, obviously, to make distributions without any sort of ascertainable standards or guidelines. But I would say that, and that makes people uneasy at times, that you give a trustee so much power. But there's also something called a letter of intent. And a letter of intent is sort of a non-legal binding document that says, I set up this trust. Here's sort of the instruction manual, trustee, of how I want you to use it. and you can guide your trustee that way. But it is important to know that that's not binding, and the third-party special needs trust must be wholly discretionary in the sense that the trustee doesn't have any guidelines within it. Self-settled trusts or the Medicaid payback trusts, again, are used for funds which the disabled person owns or owned, like an inheritance, proceeds from civil litigation. A lot of times child support will go into these in order to maximize the SSI benefit, because child support, believe it or not, is considered income to the child. Or if we have to convert an improperly drafted third-party trust in order to sort of save Medicaid eligibility, sometimes we just go ahead and convert it to a Medicaid payback trust. A Medicaid payback trust can only be established by the individual themselves if they're a competent adult, a parent, a grandparent, a guardian, or the court. And it can only be established and funded. The beneficiary must be disabled and under the age of 65. And again, the hallmark of the Medicaid payback trust is that it has this Medicaid payback provision. If it has that, then it's not going to be an accountable resource, as long as, again, it's established by any of these individuals and the beneficiary is under the age of 65. If the beneficiary is under the age of 65, there's money put into it, that's fine. And then the individual exceeds the age of 65, the money can still be used for whatever that person needs. It's just that no more of their money can go in. Like the third-party discretionary trust, these Medicaid payback trusts are for the sole benefit of the disabled individual. They can be revocable trusts or irrevocable trusts for Medicaid purposes. That doesn't make much of a difference. But again, the trustee has this broad discretion, this sole, absolute, and uncontrolled discretion to make distributions on behalf of the beneficiary. We can't put language in there that says, trustee, you must pay for this or you must pay for that. That would cause it to be accountable asset. And the theory behind that is, and the Ohio Supreme Court has basically said in a decision, if the trustee can be compelled in a court of law to make a distribution because the trust says you must act in this circumstance, then it's accountable asset. And that's why these trusts are so broad and giving the trustee this wholly discretionary distribution standard. The payback provision of the trust should not be state specific. So if the Medicaid payback trust says that the reimbursement to the state is only Ohio, then particularly SSI will not accept that as a Medicaid payback trust. It has to say state or states that have provided Medicaid on behalf of the beneficiary. So that's something that I always look for when I'm reviewing the trust, is to make sure that those little things are in there to pass muster under the Social Security Administration's rules. I'm just going to barely touch on this because Doug's going to tell you all you'll ever need to know about the stable accounts. But the stable accounts were enacted through the ABLE Act. Originally, it was established, still is, like a 529 account. Instead of a 529 account being for college tuition or educational expenses, these are for disability expenses for an individual that is disabled. It does have a Medicaid payback provision. It's a little different, a Medicaid payback provision from those that are in Medicaid payback trusts, but just be aware that it is a Medicaid payback vehicle. Right now, I believe there's a $16,000 annual contribution limit. More can go in if they're from earnings. Again, I'm not going to get into too much of this because Doug is going to do that. Social Security and ODJFS do and can exercise some oversight. I actually haven't seen it too much. This is kind of an old slide, to be honest. When these first came out, we thought that Social Security and the Medicaid agencies would exercise a heck of a lot more oversight over how these are spent. I think it's kind of a testament to how well Ohio's stable account has administered these, that they're actually so trustworthy in the eyes of Medicaid and the Social Security Administration. That's a real a benefit to all involved. And Doug will tell you, I think that there are, actually the ways that the accounts are set up and the ways that distributions can be made are sort of tailored in order to make sure that they're, by and large, within the rules of the agencies. There are some tax issues that I don't think are a big deal, but the key to remember is that the stable account monies are deemed to belong to the individual. And that's one of the reasons why we can use the stable accounts so often to pay rent. Ordinarily, if an individual is having their rent subsidized by mom or dad or by a special needs trust, that would be considered in-kind support and maintenance by Social Security. Instead, now we can take money out of a special needs trust or from mom and dad, put it into the stable account, because that money is essentially deemed to be the individual's money at that point, just albeit exempt. That can be used to pay rent, and it won't be considered in-kind support and maintenance or income by Social Security. And so we have the simple case study to just see how all this works in real life. And let's just say mom and dad have 2 kids. One of the children has a disability. They might create a revocable living trust where the trust beneficiaries are, let's say, 50% to the non-disabled child, and then 50% to a third-party discretionary trust for the disabled child. You can do the same thing on an insurance policy. You can name the beneficiary as, typically a spouse first, but the contingent beneficiaries would be, Billy, who's not disabled, and then Sally, Sally's wholly discretionary trust. And that's a way, again, to provide an inheritance for an individual that has a disability without that impacting their ability to receive Medicaid, SSI, and any of the other means-tested government benefits. In the old days, and I shouldn't say the old days, some people would just say, I'm just going to leave everything to my non-disabled child, and then tell them you need to use half of this to support your brother or your sister that has a disability, and that's okay, and that's been done a lot. The problem with that, though, is that when that's all in one person's name, that's subject to the individual's creditors. If they get into a car accident and they're sued beyond their insurance liability coverage, that could be soaked up in that. Bankruptcy, divorce, it gets a little messy there. And we now have these vehicles through these special needs trusts and whole discretionary trusts to make sure that the money is absolutely going to be there and be used for the individual. So I want to touch a little bit on guardianships. Again, this comes up when an individual turns 18. Again, I know many of you have probably been through this, and this is a little bit of review, but the review doesn't harm us at all. First of all, guardianship depends on on your state. Ohio's guardianship law is a little bit different than Indiana's and Michigan's and everything else, but the concept is the same. When an individual doesn't have the capacity to make their own decisions, whether that be for healthcare or for their own finances, then a guardian is appointed, and a guardian would be found necessary by the probate court and then appointed to make all those decisions. A guardian is actually sort of like an officer of the court. The superior guardian in Ohio is the probate court itself. There's a decision that many people have to make when their child turns 18. Do we need a guardianship, or can we use powers of attorney? Powers of attorney can name mom or dad to make decisions regarding healthcare and to handle finances. But the sort of threshold is, does the individual have the capacity to understand what they're signing? And sometimes that's a gray area, and that is fleshed out through a discussion with someone like me, or their other support that they have in their lives. I'm not saying that people should avoid guardianship. Guardianship is there for a perfectly great reason, but if you can go with what's called a lesser restrictive measure, like a power of attorney, and that's appropriate, then that avoids court costs. It avoids annual and biannual reporting, and for any finances, any accounting. There is something called a conservator, and that is someone that is appointed over a person who's not found incompetent, but basically acquiesces or cooperates with the court and says, I need someone appointed to take care of me. I see it very seldomly, because if a person has the capacity to ask for a conservator, that means they also have the capacity to ask someone to be a power of attorney. So I see this less and less, and but there is a difference, and you may have heard conservator. Now in California, a conservator is basically a guardian. You may be aware of the Britney Spears saga that's been going on for years and years. That was really what we call a guardian in Ohio. Now, the word incompetent is sort of an ugly word, if you're asking my opinion, but it's the legal term that a person needs a guardian if they're found to be incompetent. And there's all kinds of different degrees of incompetence, meaning that an individual may be fine to make their own healthcare decisions, but they might need some help or some oversight as it relates to their finances. And so there are times when a person doesn't have a guardian of a person, but they might have a guardian of their estate to make sure that they're not going to be financially manipulated by others and things like that. So the word incompetent, there's no real bright line rule for what incompetent means. It truly is a case-by-case basis, and it's established through a statement of expert evaluation filled out by a physician. It's also determined by a court investigator and all of those involved. And the ward is the individual for whom the guardianship is set up. So what rights are affected by guardianship? The guardian has the right to determine the residence of their ward, usually their child. And so, again, these rights are vested in the guardian and not the individual themselves. Over the years, the guardianship law and culture, frankly, has developed to, if at all possible, include the desires of the individual to the greatest extent possible. The courts are very much looking to the individuals. If they have, some capacity to say, I want to live here, I don't want to live here, and this is why, the courts are honoring those wishes more and more, which is nothing but a great development. The guardian then can consent to medical treatment and make end-of-life decisions. Depending on the circumstances, an individual subject to a guardianship may or may not be able to have a driver's license. They may or may not be able to own, manage, or sell their own property. Again, it just depends on the circumstances. In certain cases, a guardianship is established to make sure that an individual can't obtain a firearm. Certainly, when we have cases where a guardianship needs to be established so that an individual won't be unduly influenced by others financially, a guardianship of the estate would prohibit that individual from entering into contracts or fill out a credit card application, for instance. And if they do, they send it into the credit card company, the credit card is sent out, and the individual uses it. If there's a guardianship in place, it's an invalid contract. The right to marry can be affected by a guardianship. Typically, when an individual wants to get married and they're subject to a guardianship, you have to get probate court approval, because again, a marriage is a contract. And if you're found to be incompetent and you need a guardian, then it's not saying people can't get married, but again, the right to enter into even a marriage contract is vested in the guardian and the probate court. And also the right to vote. Again, not saying that any individual that's subject to a guardianship can't vote, but that may be a question that arises. Are they able to? And if they are able to, it would need to be essentially approved by the probate court. So to establish a guardianship, you first file a petition, an application to establish a guardianship in the county probate court where the person lives, not where the applicant lives, but where the person lives. You include a medical affidavit or that statement of expert evaluation filled out by the physician that I spoke about earlier. And the court will appoint a guardian ad litem or a court investigator to give notice to the individual and advise that individual of their rights. They're presumed to be competent until they're found to be incompetent in probate court. There's a hearing. That hearing in most cases, particularly when mom and dad are the applicants, is a very informal and relatively short hearing where the Magistrate in most cases is going to just make sure that everybody understands their rights and their responsibilities, and that the guardianship is the best course to be on. And then the guardian will get what are called letters of authority, and these letters of authority are sort of the piece of paper that says, I am the guardian of my child. And you would take that to the doctor, you would take that to the bank, you would take that to whomever needed to prove that you were the guardian. Again, the guardian's duties are to make decisions in the best interest of the ward, considering the person's wishes and preferences. And that considering the person's wishes and preferences isn't new, but it's being given a lot more weight and focus. An individual who's the guardian over a person's money may be required to post a bond. And a bond is basically an insurance policy that says if the guardian absconds with the money, the insurance company will make the guardianship whole, and then that insurance company will go after the person that stole the money. If there is a guardianship of the estate and you want to make a purchase, you have to get probate court approval through an application for authority to expend funds. That's not to say that for every dollar you spend, you need to go get specific or explicit permission. Most of the time we'll establish a budget that says the guardian is permitted and authorized by the court to spend $200 a month on personal care, or $500 a month on medical care or on travel or things like that. And then the guardian has to act within those parameters. The guardian of the person is the individual that makes the non-financial decisions, making doctor's appointments, talking with doctors, and things like that. So consent to medical treatment, monitoring medical treatment, determine placement in a proper setting, whether that be in a group home, whether that be in the community with mom or dad, whether that be in a hospital, a mental health institution, or anything else like that, as well as obtaining programs and services, even through the DD board through its waivers and other things like that. The guardian of the person is also responsible for and has authority over the individual's protected healthcare information and any other confidential information. They can consent to the release of that, or they can refuse to consent to the release of that. It's the guardian of the person, though, again, that is vested with the authority to make those decisions as if they were the individual themselves. And again, we talked about this before. It's not fun to talk about, but the guardian of the person can make end-of-life decisions, like whether or not a doctor should issue a do not resuscitate order and what kind of do not resuscitate order should be issued. Also, whether or not a feeding tube would be withheld or withdrawn if the individual is permanently unconscious with no medical possibility that they'll come out of that. A lot like living will, the guardian of the person is nominated to make those decisions. The guardian of the person, again, I mentioned this earlier, must file regular reports with the court. Those reports are typically in the form of a guardian's report, which goes back a year or 2 years, depending on the probate court and the county that you're in, saying this is what happened, this is what we did. And then the guardian's plan is saying, okay, going forward a year, this is our plan. They're about one-page reports that you can fill out the forms online and file them. And if you're a guardian of a person, you get notice from the court that your report and your plan is due. And if you're involved with a lawyer like ours, our firm, or something like that, we'll send you notice when we get the notice as well. And that's the extent of the reporting requirements for a guardian of the person. As opposed to the guardian of the estate, who is in control of actual assets and receives the income. Again, you have to make appropriate disbursements only with probate court approval through the filing of these applications for authority to expend. You have to file an inventory of all the assets, and then biannual accountings with the court showing all the money that was received, and then also what you spent all that money on. And then a lot of times a guardian of the estate will be appointed in order to prosecute or defend any lawsuits on behalf of the ward. So again, if there's a, you're the guardian of the person, but they get into a car accident and there's an insurance settlement or something like that, that individual would need to become the guardian of the estate in order to settle that claim, have the probate court approve it, and then be responsible for those assets, which may also include petitioning the court to create a special needs trust so the individual can maintain their Medicaid eligibility. There are other types of guardianships, limited in scope or duration. I mentioned this earlier. There can be limited guardianship of the estate just to prevent an individual from entering into contracts or taking out loans or being financially abused or manipulated. Emergency guardianships are necessary to prevent injury to the person or estate. And that is immediate, like life-threatening personal danger that the individual has to be in. A lot of people call me and a lot of people say, I need an emergency guardianship. And I would say 99% of those are not appropriate for emergency guardianships. Emergency guardianships are for circumstances when the person's life is in danger and you need to get some control right now. A lot of times they come out of hospitals, and many of you have probably heard the term being pink slipped. That's an emergency guardianship, which essentially appoints the court over a 72-hour period to make all those decisions. Then there's an interim guardian that might be to replace a former guardian. It might be just the court itself or a court-appointed attorney to make sure that things are in place in the meantime when a guardian might pass away and we need to have another guardian apply. And there's a 15-day max and you can get a 30-day extension. But that's, again, just to make sure that with the probate court being the superior guardian, that someone always has eyes on the individual and that their best interests are always going to be protected. So when is a guardian needed? Prior to the age of 18, the parents are the natural guardians. At age 18, again, the parents' income and assets, as I've said, are no longer deemed to the child, which allows them to obtain SSI and Medicaid eligibility. But what that also means is the parents are no longer the legal decision makers for the child. And so, again, the question is, can the child sign a power of attorney for finances and for healthcare? Would they understand that? Does that make sense? Do they have the capacity? And if not, then you would want to apply for a guardianship. So in order for the court to find that a guardianship is necessary, the individual has to be deemed incompetent in at least one important area of taking care of themselves, okay? This, again, establishes the need for a guardianship. And there must be no other lesser intrusive measures in place. If an individual already has a power of attorney because they had an accident and became disabled or something like that, but they already had a power of attorney for finances and for healthcare in place, then there's no need for a guardianship because you already have someone that is named to make those decisions on the individual's behalf. And it was their decision to grant that power of attorney to someone else. If that's not in place, then again, a guardianship is necessary to protect the person and to control and protect the assets of the individual and use those assets in the best interest of that person. So a guardianship of the estate is necessary when the assets are over $25,000. And so most of the time, even if there's a guardianship of the person available or necessary, and the person gets an inheritance of $15,000, you can ask the court to just allow the guardian of the person to move that money into a stable account or into the special needs trust or to spend it on certain things without going through the rigmarole of establishing a guardianship of the estate, which again requires all these things like perhaps to post a bond, to file an inventory, to file accounts, to have to ask over and over for permission to expend the funds. This is not pursing and settling personal injury cases, it's pursuing. So that's a typo on my part. But again, if an individual has a birth injury and then there's a settlement, a guardianship of the estate has to be established in order for them to prosecute that claim. And then if an individual has real estate, in order to purchase or to sell that real estate, a guardian of the estate has to do that, and that has to be administered through the probate court. And then if there's a need for benefits, like applying for Medicaid or SSI or things like that, and the person just doesn't have the capacity at all, or there's no other availability for that, a guardian may be needed to be established. Although in most cases, applying for Medicaid and SSI does not require the guardianship of the estate, even when one may be necessary technically. So what are some alternatives to managing funds in guardianships? Representative payee. So if an individual is eligible and receiving SSI, SSI will appoint a representative payee, and that is in lieu of needing the guardianship of the estate. Again, a trust, if the money is in a trust, you don't need a guardianship because the trustee is managing those assets on behalf of the beneficiary. You can deposit funds into a restricted account, a custodial account, for instance, where the individual can't access it. The other thing is a durable power of attorney. Again, if that's possible, then that durable power of attorney can be the one that does all the banking and can put banking restrictions on withdrawals and things like that. When we say banking supports, what we're really talking about is, contacting the bank and saying, please don't allow any withdrawals over $10 or $25, or if there's any activity, I need to be notified. And so there has to be 2 signers on any transaction or something like that. Banks are generally, accommodating with some of these supports so that the money is protected, because after all, that's what banks want to do, is protect the money. So I realize I blew through that and we have some questions. I want to take the next 5 or 10 minutes to answer those questions. So I'll just dive into the chat box here and go through them. And then if anybody has any more questions in response to these or anything else, let's take care of those now. So the first one is, can you tell us why the child receiving deceased parents' SSDI is eligible for Medicare, and what happens to Medicaid? So it's a good question. Remember what I said is a person can get SSDI through, if they were eligible or if they were deemed disabled prior to the age of 22, they'll get SSDI when a parent dies, and they'll get 75% of what the parent's benefit was. 2 years after receiving the first Social Security disability payment, the individual will get their Medicare card. Those two are linked. It's akin again to regular Social Security retirement at age 65. You can take it. You also get Medicare. So it's like early retirement through that. In most cases, individuals will want to keep their Medicaid, because the Medicaid is what provides for the waiver services, for things that Medicare doesn't pay for, like institutionalized care, and even co-pays and deductibles and things like that. So we have dual eligible individuals where they have Medicare, but they also want to maintain their Medicaid. The next question, what's the advantage of Medicare when a child is already receiving Medicaid? Well, Medicare is generally, I probably shouldn't say this because I don't know how true it actually is, but it's a little bit better health insurance than your base Medicaid. And it pays for things like more akin to private insurance does. Think about, a person who obtains the age of 65, they get Medicare. That's your health insurance. So Medicare is a little bit better. It's also not means tested, so you don't have to worry about the $2,000 in your income and things like that. However, again, like I said, Medicare doesn't cover everything. It doesn't provide the support through the funding through a waiver that Medicaid does. So Medicaid is necessary to keep receiving your waiver benefits. Again, Medicaid will pay for things that Medicare doesn't pay for. So even co-pays, excess medical bills, the individual has Medicaid can submit those bills to Medicaid and those will get paid. Next question, what happens when the guardian dies? When the guardian passes away, remember the probate court is the superior guardian. So they retain jurisdiction. The probate court will be notified by a next of kin, a family member, or they'll find out on their own through natural government reporting, like through the Social Security Administration. and someone else would need to be appointed. In the interim, the court may appoint an interim guardian to make sure that everything is taken care of. The next person to come along needs to apply, and they need to be found suitable themselves. An individual guardian can nominate who they would like to serve if something happens to them or if they want to resign. That nomination isn't binding on the probate court. The probate court always has the duty and the ability to say, I know you were nominated, but you are not a suitable guardian, or of course you're the next suitable guardian, your dad or your sister or something like that. But that still is another application process that's a little less structured and intense as the first one, obviously. Okay, the next question, do you need a representative payee in order to open a bank account if you were the guardian? No, representative payee is always for Social Security benefits. If the individual needs help, you're going to be appointed as the representative payee to receive either SSI or SSDI. If you're a guardian, the individual may not be on Social Security benefits, but you as the guardian of the estate have the ability to open a bank account in your name as guardian and then deposit the individual's funds in there and then use those with court authority. Says I'm a guardian, but waiting for the representative payee form. Yeah, so, and really you're talking about two different things, because the probate court doesn't exercise any oversight over the SSI or the SSDI. It would only be assets that are over $25,000 or any other income that was coming in, maybe from rents or something like that. So I know it's kind of confusing, but they are two separate sort of hats that you'll wear. You can be the guardian, at the same time you'll be the representative payee, and they don't, I mean, they're obviously related, but they're not, the representative payee is not under the guardianship, if that makes any sense. And for right now, the last question, is Social Security retirement, survivors, and disability insurance considered Social Security disability? Retirement, survivors, well, there's Social Security retirement, which is what a person receives based on their age and their payment into the system. That's sort of what everybody knows as, you know, I'm on Social Security now. Survivors is when mom or dad passes away and a minor child gets a survivor benefit until a certain age, or a surviving spouse can get a survivor benefit from the deceased spouse. And then the disability insurance is Social Security disability, as we've been talking about. SSDI is the Social Security disability insurance. And again, I akin that to your early retirement based on either your own payment into Social Security or relying on your parents' Social Security input if you were disabled prior to the age of 22 and the parent has either retired themselves, become disabled, or passed away. This is a lot, I know, everybody, and we oftentimes do what we call trustee school, where we go through all of these things over and over a couple times a year, and we just review it with all of our current clients, basically anybody else that wants to hear this. And I repeat myself a lot because all of this needs to be repeated, and there's nothing wrong with having to go over this, you know, sort of even a few times a year, just to make sure that you're understanding everything that's going on, because it's all so important and so intertwined. Okay, next question. If I have a special needs trust from another state, does it need to be updated in Ohio? Probably not, as long as it's a well-drafted Medicaid payback trust or special needs trust that conforms with Social Security's rules. Social Security is a federal program. Those rules apply to everybody in the United States. If there's a special needs trust for Medicaid payback trust drafted in North Carolina, in order for that to be effective, it would be the same rules in Ohio. But if you do have a trust from another state, I would highly encourage you to have someone take a look at it just to make sure that it makes sense under our rules. And if it doesn't, there are ways to modify or reform even an irrevocable trust to make sure that the intent of the grantor, the person that set up the trust, is being followed. Next question, is the $2,000 limit required when using Medicaid when receiving Social Security disability from a deceased parent when using Medicare? Well, I think I understand the question. Does the $2,000 requirement still apply? The answer is yes, if you need Medicaid. So even if you're getting Medicare and Social Security disability, if the individual's on a waiver, that means they still need Medicaid, and you still need to pay attention to that $2,000 asset threshold. And that's why through the course of a special needs plan, whether that starts at birth or at 18 and on throughout the life, we're almost always at least mildly concerned about maintaining Medicaid eligibility, because Medicaid is the foundation for so many of the other benefits. Again, most notably here, the waiver benefits. And then one more here, or a couple more. Says, thanks for reminding us that this is all complicated. It takes time to understand. Yeah, it is. I spend my life talking about this, and again, I spend my life repeating myself, even to myself, about the nuances between Medicare and Medicaid, and verifying when I meet with a new family, verifying exactly what those benefits are, because the implications of exactly what they are have, the feelers on that go out to just about everything else. So, all right, one more question, it looks like. Can you review the difference between the Medicaid Payback Trust and the non-Medicaid Payback Trust? Okay, so this is a great one to end on for me. If you walk away from anything tonight from me, it is that there are two types of special needs trusts. The trust that holds mom and dad's money or anybody else's money is the third party wholly discretionary trust that does not have the Medicaid payback provision. The trust that holds the individual's money, whether that be from inheritance, a lawsuit, a settlement proceeds, whatever the case may be, has to have the Medicaid payback provision. So the question is, whose money is going to be in this trust? If it's the beneficiary's money, then it's the Medicaid Payback Trust. If it's mom and dad's money or anybody else's money, it's the discretionary trust. Okay, so that's the main difference. There's many other differences, but that, and many of you might already have both a third-party trust and a Medicaid Payback Trust. And it's important always to remember whose money is going into these trusts. So, I mean, my clock says 7 o'clock. That's exactly an hour. I'm pretty proud of myself for that. I know I was talking fast. Many more questions as Doug continues. If you have more questions for me, put them in the chat box, and we can always address those later.
Very good. Thank you, David. We really do appreciate the information. And I think that really was a good question to end on, because I think I see heads nodding, at least in here. So that helps.
Good.
Okay. So Doug, you are up with stable accounts.
Yeah, thank you. And following David, that's always a tough act. I am not an attorney, but hopefully the knowledge that I have in stable accounts will be just as beneficial to you as the knowledge that David shared about trusts. First, let me just apologize for the hoarseness that I have going on in my voice. Ohio allergy season has kicked my butt, but hopefully my voice will hold out. You'll probably see me taking a drink of water or tea that I have here with me quite a few times this evening, but this isn't my normal voice, but we are still going to engage in this presentation. Just like David invited you to do, if you want to ask any questions, feel free to type them into the chat. If I don't see those and Jody does and she interrupts and asks at that time, that's fine with me. I really want it to be a conversation. If you're comfortable with it and you want to turn on your video, feel free to. If you want to unmute yourself to ask a question, feel free to do that and then put yourself back on mute. And we'll try to keep the audio of this going well. So welcome to an information session on stable accounts. We are going to talk about some of the same things that David talked about as we look at the purpose of stable accounts. We'll talk about how that overlaps with trusts, how they benefit each other. I oftentimes get asked the question, which do I need, a stable account or a trust? The answer is yes. It really just depends on what you're trying to accomplish, where the money is coming from, and we'll reinforce those ideas throughout this part of the presentation. So an ABLE account, it actually came from advocacy that people with disabilities took to Washington, D.C. and said, we are tired of being kept poor, not being able to save more than $2,000 and keep the supports that we need. So that $2,000 resource limit is something that David talked about. And that is true in many public benefit programs. Two of the biggest are those ones that we've been talking about through this presentation, SSI and Medicaid, or Supplemental Security Income and Medicaid. Other public benefit programs also have the resource limit, like some of the food related programs, housing related programs. Others do not. So SSDI is not resource tested. So it is important to know which programs are how limited by that $2,000 worth of assets or resources. SSI and Medicaid, of course, are two of those big ones. So an ABLE account came into existence because the federal government said, we want to create an opportunity for people with disabilities to save in a protected account. We're going to call that ABLE, stands for Achieving a Better Life Experience. And ABLE accounts are kind of like other existing accounts. So they're kind of like a 529 college savings account in that you can save for the future. They're kind of like a checking account because they are transactional. You can actually start using it at any time when you need it. And it's kind of like a trust because it is a protected resource, like David explained about the special needs trust, not counting towards that resource limit. In Ohio, Ohio took the federal regulations, which allowed each state to have an ABLE program. We created our own. We brand named it Stable Account. So it is a national ABLE program. So it is offered to Ohioans, but it is also offered to anybody outside of Ohio. So we actually have people from every state in America, as well as Puerto Rico, Washington, D.C., and military serving abroad, taking advantage of stable accounts. So it's definitely something for Ohio to be proud of because in Ohio, this is our plan. In other states, they might have their own state plan and still look to our plan as being a better opportunity for them. I'll talk about what makes our plan good and why people would make that choice. Our first account was on June 1st, 2016. So we're quickly approaching 6 years worth of being in business or providing services to people with disabilities. That's a long time. That means we have over 28,000. We're going on 29,000 people utilizing stable accounts. So you would not be the first person signing up if you have not already. Hopefully that provides you with a testimonial that things are going the way they're supposed to go with this program. They're tried, they're tested, and that's a good thing for you. Excuse me. I promise we'll make it through this. So the benefits of a stable account. The account is owned by the person with the disability. And that's very important. The trust is a little different because the trustee is actually the one over the account. The stable account can have somebody manage it for them, but it is still the money of the person with a disability, which allows for that financial independence. There are some tax benefits to it. So money going into it in Ohio can be taken as a state tax deduction. It also grows tax-free. So if it is growing in the account because of investments, it's not going to be taxed while it's in there. It's not going to be taxed when it's taken out. So a couple different tax advantages there for you. So who is eligible for a stable account? Well, first of all, our website would have the answer to that. We have an eligibility quiz. If you don't know whether or not you're eligible, then you could go to this and determine for yourself whether you're eligible for the account. But it is for people with disabilities that the onset of the disability was prior to the age of 26. So that's the onset. Many people are born with disabilities that would obviously be before the age of 26. And some people become disabled later in life. As long as that disability occurred prior to the age of 26, you would qualify. Then any one of the following three criteria. So the following three criteria are eligible to receive SSI or SSDI, automatically makes you eligible for a stable account, or any condition listed on the Social Security Administration's list of compassionate allowances conditions. Don't just think about developmental disabilities, think about other things like mental health conditions or medical conditions that are disabling. So very broad list. All right, do we have any questions yet, Jody? All right, we will move on. So self-certification. Self-certification would mean that you have this disability diagnosis from a medical professional. That's what we're looking at. That means that you can tell us that you have this. You keep it on file. We don't ask for it, but if we needed it, you could produce it. So not only is it self-certifying, but we allow you to attest that you have it and you don't have to submit it to us. So our enrollment is done online, stableaccount.com. If you walk away with one thing from this presentation, it's knowing the website, stableaccount.com. It's an easy process, about 20 minutes long to get through from beginning to end. And there is an opening deposit. It's a $25 opening deposit, but that just creates a balance in the account. That is not a fee. It just funds the account. Enrollment can be done by the person with the disability. But if the person with the disability, and David used the word capacity as he talked about guardianship, if they have capacity or not, then they, in the stable account case, could have somebody else manage the account for them. And that would be a power of attorney or POA, a guardian who has the ability to oversee finances, a spouse, a parent, a sibling, a grandparent, or a representative payee. Okay. Looked like we had a question pop up. We'll wait to see if that gets fully typed out. That's great, Jordan. Thanks for letting your 1-year-old be with you as you listen to this. We'll move on from that question. The entity ALR. So if you work with a provider agencies can also manage stable accounts. Typically, they're doing that as a representative payee. They could also do it as a POA. But we simplify the process for those who are managing multiple accounts. So I won't spend a lot of time on this, but it's important to know that we do work very closely with providers who might be managing multiple accounts. How do you get money into the account? Well, the first way is through the electronic funds transfer. It's just like online banking. So you transfer money from an existing account into the stable account and back out if you need to, and we'll talk about that during spending. You can also mail in a check. So we don't like to call it the old-fashioned way. I still write checks. Many people have moved to the electronic ways. But if you want to write a check and mail it to us, I'll give you my home address. You can mail it. I'm just kidding. It's not my home address. It is a PO box that you'd be mailing that to. We also work with payroll deduction. So payroll deduction allows a working person to have money taken out of their paycheck and put into a stable account. So let's say that it's a family member of a person with a disability, maybe mom and dad. They could take their paycheck and have part of it put into their child's stable account. Or if it's the person with a disability who's working, they could have part of their own paycheck put into their own stable account. there are some account limits. Now, these limits are very high. If we look at what these are on an individual basis, you'll see that not many people, even without disabilities, are saving this amount of money every calendar year. So funding the account for a person who is not employed, that's the person with a disability who's the account owner or the beneficiary of the account, they can put in up to $16,000 per year. That's from all sources. So that's the contribution limit per calendar year. If the person with a disability is working, they can also put in their earned wages up to the federal poverty line above and beyond the $16,000. So for a total of $28,800 in 1 year. With a lifetime balance limit of the account at $517,000, that's over $500,000, still able to keep public benefits. One other way of getting money into the account is what we call the gifting page. So the gifting page allows for a person to create a web page in their stable account. This is all an automated system. Copy the link. Sorry for the choppy audio here. I know I have to keep muting myself. They can copy that link and then email, text, get that link out to any person who receives it, which can then click on the link and make a contribution into the stable account. That money would then not count as a resource and it would not count as income because it's protected in the account. Once the money is in the account, then the person has a choice, either the person with a disability managing their own account or the person as acting as the authorized legal representative can make the choice to put it into what we call the bank safe option, which is just like a savings account, or put it into investment options. So investment options are 4 different Vanguard mutual funds. So you can use one of these 5 options. You can use all of these 5 options. It depends on what you're trying to accomplish and how comfortable you are with investing. But investments, again, they grow tax-free. So while they're in the account, they are tax-free. When they're taken out of the account, they remain tax-free. To those who want to take advantage of investing, that is a huge benefit of this account. Putting in money, having a large balance, having it invested. The markets have been doing well. Historically, they have since we've been in existence. But we know the markets will go up and down. So at some point, the market will go down. People investing their money will likely lose some of that money. Over the long period of investing, it's expected that you would then come back to gaining more money. So what can you spend the money on? Well, you can take the money out of a stable account, use it to buy things, anything that relates to the person's health, independence, or quality of life. So it does have to be for the person with a disability. This isn't to be spent on other people or given away. For the person with a disability to pay for health, independence, or quality of life. Very, very broad definition. Look at some of the categories on the screen. These are not all inclusive. They're just some examples, but housing and rent, basic living expenses, which includes food, transportation, education. There's many different examples here. We always get asked questions. What about this? What about that? We never answer yes or no. We always say, can you justify that expense as health, independence, or quality of life? So then once you know that you can take the money out and what it can be spent on, how do you actually get the money out? How do you get to pay for things? The first way is to take it out of stable account, transfer it back to a checking or savings account. Then you can spend it from that personal account. A second way would be through what we call a third-party check. So a third-party check allows you to log in a stable account, tell us who needs paid, and we pay it for you. So it is a check that goes out to that vendor or person to receive that payment. But it takes some days to mail it there. So the processing and mailing. So If that payment's due tomorrow, don't log on today and expect that it's going to be there today. But the third-party check is great for things like rent. So paying rent, you pretty much know every month that it's going to be the same amount going to the same place, the landlord, and you could log on to your stable account and have that sent by logging in, days in advance, set your reminder to allow enough time, and then it can go directly to the landlord. Now we have also set up what's called recurring third-party bill paying. So for rent, you could turn it to auto payment, and every month on the same day, it would generate that payment to go to the same vendor. So third-party checks can be a real benefit. We also have the stable Visa card. Very popular feature for us. So the stable Visa card is a loadable debit card. It's used to make purchases any place that Visa is accepted. You can load money onto the card. And once the money is loaded onto the card, that's all the access the account owner has to spending. So if somebody else is managing the account for the account owner, we'll call it a monthly allowance. Let's say that the team has decided that this person, the account owner, should have $100 a month out of their stable account. Well, the account manager can put $100 on the card. That's all the card can spend. Then once the card is spent, all $100, more money would have to be loaded on. So it's a great way to put some checks and balances in place for how much access there is to money, but still providing the access so that funds can be spent. Now, we spent a lot of time, especially David, talking about the different Social Security programs, SSI being, again, one of the big programs for people with disabilities that they may be utilizing. SSI is for food and housing. Food and housing to be paid for by public assistance. Again, even if you have maximized SSI payments, $841, $850, somewhere in there, you're not really going to have enough money for food and housing by SSI alone. Typically, that is subsidizing other forms of money that you have, whether that's other unearned income or earned income or money given to you by somebody else. But if your stable account gets to be over $100,000, any amount over the $100,000 is going to count towards the $2,000 resource limit. If you hit that $2,000 resource limit, then your SSI is going to be suspended. Now you might ask, why is that? Well, SSI is for food and housing. The Social Security Administration has said, if you have $100,000, you have enough to pay for food and housing. So I understand that rule. Now, the next rule, or the middle lines on this screen, is an interesting one. Social Security likes to make up rules. They made this one up. We have helped to protect people from violating this rule by utilizing the third-party checks. But if you are taking money out of your stable account for housing-related expenses only, those expenses must be paid the same month that you take it out of your stable account. Again, going back to the third-party bill payment, if you're using that, then once you request the third-party bill payment, that money is considered paid as soon as you requested it. You're not holding on to that money. So we solved that problem for you. But it's also important to understand that if you are receiving SSI, SSI is based on both income, how much you earn, and how much you save, or assets or resources, whatever you want to call it. Earned wages will always count as earned wages. You can't hide or shelter or shield or reduce countable earned wages. Now, there might be some games to play to reduce some of that by work-related expenses and some of those other things, but stable account will not reduce your countable income. So that's important to know. So Cindy and David asked a question: are there fees for credit card monthly or per use? Thank you, Cindy and Dave. The answer to that is no. Now, this account does have some fees. We're going to get there in just a minute, but the card is no additional fee. Now, you have to request the card. It's a simple request and we send it to you, but we don't send it out to everybody because not everybody needs to use the card. But for those using it, we send it out and you can use it at no additional cost to you. So what happens if the stable account owner passes away? Well, David had talked about first party trusts or Medicaid recoverable trusts in a stable account. If the person with a disability, the account owner, passes away, then the money in the stable account does have the ability for Medicaid to look to the account to recover or ask back for some of that money. What are some of the limits here, though, that protect it or make it different than a trust? So a first party trust would look at the value of Medicaid services over that person's life, and the amount left in a first party trust could be completely recoverable. On a stable account, what the Medicaid agency looks for is the amount of Medicaid services, the value of Medicaid services from the date the stable account was opened forward, but not the Medicaid services that have been provided in the past, just today when you open the account forward. That's a protection to start with. Other protections are that the stable account can pay for any outstanding qualified disability expenses. So before the estate gets stuck with those bills, the stable account can pay for those bills up front, including funeral and burial, which is a big expense in itself. So paying for funeral and burial out of the remaining balance of a stable account may completely wipe out the stable account. Funeral and burial easily could be $10,000. The average stable account balance right now, so this is over 28,000 people using it nationwide, the average account balance is a little over $9,000. So for the average account, paying for funeral and burial would wipe out the account before Medicaid could have any recovery. But if there are still funds left in the account, Medicaid could recover those funds. Now, some people would say, well, I don't want Medicaid to get a dime on my money. Other people would say, you know what, I got a lot of Medicaid services while I was alive at no cost. Whatever I have left, Medicaid can have. I'm not here to make arguments on either side of that. But what we can say is that a stable account is actually the most protected way for funds that are first party funds. For third party funds, as David talked about, the third party special needs trust, money coming from somebody else to the individual with a disability, third party trusts are a much better tool for protecting third party funds from Medicaid recovery. So knowing what tools exist and how they work together is very important. So to the question regarding the fees, here is a slide completely about just the fees of the account. These are all of the fees that are associated with the account. $2.25 a month. That's actually charged quarterly, but it equals $2.25. That's for everything. That's to all the record keeping and transactions and account statements electronically, and all of those things fit into $2.25 a month. Asset-based fees are the investment fees. If you know investing, you know that these are very, very, very low fees, 0.19 to 0.33%. So that is going to come off of the top of the growth of that account if you are investing to pay for the investing option through Vanguard. Now, if you're out of state, you're actually paying more for the account. But people, I told you in the beginning, and I think this is even more so a testimonial to Ohio's account, they are paying more than an Ohioan would pay and still willing to pay that because of able accounts across America cost money. Ohio's is about an average price, but it's an above average product. We have a great product compared to the other ABLE programs. So a great way to kind of wrap up how these tools work together. Trusts, great tools. We like to call them complementary tools to stable account. Trust can make a distribution to a stable account, which is a great way to broaden the spending power of the trust. Trust not able to pay for food and housing without having some negative impact on the person's benefits. A stable account can pay for food and housing. So if you took money out of the trust, put it into the stable account, and paid for food and housing out of the stable account, you've just made the trust work better for the individual by utilizing the stable account as the spending vehicle. Also, trust can accept unlimited cash and non-cash assets, where the stable account is limited to that $16,000 a year or $28,880 if you're employed. The trust does not have that limitation. So it's a great tool if you're working with more assets, more money. The stable account has the state tax deduction for contributions, money going in. Stable account also has no federal or state taxation on the earnings. So that's a benefit to it. Really one of the biggest differences, and this is just important to consider, it doesn't make it better, it doesn't make it worse, it's who is administering each tool. So if the person with the disability says, I want to manage my own stable account, they can do that. If the person with the disability says, I want to manage my own trust, they cannot. A trustee would be in place. Now, again, what's the circumstance? What's the capacity of the person with a disability? How much engagement do they have with their financial resources and planning? All of those need to be taken into consideration. So we have a team of people here to help. So our customer service is a great resource. After this presentation is done tonight and you think of a question, you could still call, you could still get an answer. You could send us an email and we'll answer that email for you as well. Or you can find a lot of information on our website. So frequently asked questions are there. Other product and information and just explanations are there. So really good resource there. With that, I know we are ahead of schedule right now. My voice is thanking me for that. You're probably thanking me because you're tired of listening to me cough and a hoarse voice. But let me see if there's any questions.
Well, first, Dave, I want to just thank you. I know it was a tough to present tonight with the allergies, but we do appreciate it, and you did a great job. And I don't think anybody here felt anything more than a little bit of sympathy for you, because we've all been there.
Thank you. Doesn't look like any questions are coming into the chat right now.
Are there any questions in the room?
And I know David is still with us, so if there's any follow-up questions for him too, we can definitely make sure that he's available to answer as well.
Any more questions for anybody on Zoom? It's when you're typically like panic typing, trying to get the words in there fast enough, you know, you think that
Right.
we're going to say there's no more questions, but okay. Well, let me just remind everybody real quick that again, on our Deepwood website, so Lake County Board or lakebdd.org, if you go to the link for resources, there is a link for family forums, and this will get posted. Again, give me about a week. I do apologize. I just need to apologize from the April family forum. We did have some technical difficulties with the audio, so we really just couldn't, we couldn't even post that, but the presentations are posted there, the PowerPoints, so you can still access that. I believe that this recording is going just fine, so I don't foresee a problem with that. And then just a quick announcement. In July, we're not going to have a family forum. In June, we will have one in July. And that one's going to be a little bit more fun. We're going to do a luau up with our community recreation group up on top of the hill. And we're also going to have information there for our self-advocacy council. Okay, so think about joining us for that. Just kind of some fellowship, some networking with each other, some good food, and a little bit of fun. Okay, all right. Any questions on Zoom? I don't see any coming in.
It looks like Joe put one in. He said, to manage this account, will it require a POA for an adult parent? Would the adult parent be the person with a disability? Joe, you're welcome to unmute too if you'd like to just speak it to us. Jody, can they unmute? Yeah, go ahead.
No, I was just wondering, he's 12 years old right now. And we thought about if we put an account in, it's not like an account where you have a joint person on the account, do you? Or is it?
No, so Joe, just to clarify, so the person with the disability is a 12-year-old child?
Yes.
Okay. So under that, you do not need a POA because in Ohio, the parent has the ability to legally to manage the child's finances. And this is a financial account that you can manage as a parent. So no extra documentation is needed. When your child turns 18, then they hit the age of majority. And unless the courts have proven that person to not be competent to be their own guardian, it would become the child's account at age 18, which means that they could then manage the account. If you'd like to continue to manage the account after the child turns 18, then a POA would be a good tool to use because you wouldn't have to go to the extent of becoming a guardian of a state. So but your child has to have the capacity to sign that POA. So they're their own guardian still. They can designate who they want to manage their stable account for them. And that could be you. Now, if they don't have that capacity, then we're looking at guardianship at that point.
Okay, one other quick question.
Sure.
If for some reason he has autism, it appears that he probably will need assisted living as an adult at this time, but who knows? The world of medicine may change and he may become self-sufficient at one time. If you open a stable account and all of a sudden there's disability disappears or you're in trouble now, right? You're taxed for everything, or how do they handle that?
Yeah, that's a good question, Joe. I mean, that obviously is a more rare circumstance, and we hope for it, right? Every parent of a child with a disability would hope for that to happen. The account can, first of all, remain open with no further contributions into it, is one way to manage it. Anything related to what was the disability. So some disabilities would have like ongoing screening to make sure that the disability isn't getting worse or returning or something like that could continue to be paid for out of it. But worst case scenario is disability disappears, and that's best case scenario, but worst case for the stable account. And you no longer can spend it on what's called a qualified disability expense because the disability is no longer there. The penalty would be on the interest earned to pay the taxes on that interest earned. Then you have to look at how much is in the account, how much interest was earned. If you were investing it, that could be a little more, but if it was in the bank safe option, that might not be anything.
I'll tell you what, it'd be worth every penny of it if that was to happen.
Yeah. I'm glad that you're picking up on that because I want to be fully transparent. There could be taxes to be paid, but even if you're paying them, it's not going to be much. And to your point, it would still be worth it.
Yeah, absolutely.
But you're not going to lose the money as a good thing to stay in also.
Okay, thank you.
Yeah.
Any more questions, either for Doug or for Dave?
I'm sorry, I do have one more. Looking at both options that we're talking about, the stable accounts or a trust, is there a monetary, for example, I don't see contributions going into either one of those totally more than $30,000 or something in that nature. Is one vehicle better for a lower amount than, I would imagine if you had $1 million, you'd want a trust. But is there like a dollar amount that you say it's worth investing in a trust versus just doing it in a stable account?
If David wants to jump in, he's welcome to. Oftentimes, a financial planner is going to answer that question, but there's some general things to think about with the family dynamics. One of it is, how much time period is it going to take to reach that $30,000 worth of contributions that you're talking about? If you're doing it over years, $4,000 a year can be a state tax deduction going into a stable account. So you could take advantage of the state tax deduction that you aren't going to gain from a special needs trust. But that $30,000, whether it's put in in a short time or a long time, is all Medicaid recoverable. So if Medicaid services are being provided, Medicaid could do a callback or a recovery of that value of services, and all $30,000 goes back to Medicaid if the child passes away. So putting it into a trust, it's protected. The child passes away. It goes where you say it should go next after that child had passed away. So it really just depends. I mean, there's some risk involved in how long the child's going to live for, how long that money is going to last. Some of those things play into it. But
Well, it says that we have a lot of grandchildren, and right now, my wife opened up custodial accounts, and there's minimal amount of money in that. And he's 12 years old. I think it's time I better get that out of there and put him in something.
yes,
That's what I guess, and I don't see this as being an enormous amount of money, but I'd rather see him have it than the government get it.
right. Yep.
Okay, thank you very much.
Yeah.
I have a question. Why don't you come on over here so he can hear you? I'm going to put somebody on that has a question.
This is for Dave. If I look at the guardian of estate, okay, because my brother and I are going to be, guardian of person. We're going to be the guardians for my brother who's autistic once my 93-year-old mother passes away. So what does this mean down here again when it says file regular reports with probate court? What are those reports you're referring to?
So for the guardian of the person, the regular reports are going to be what's called a guardian's report. That is, in some counties, it's filed annually. In some counties, it's biannually. That is a report of what's happened in the last reporting period. And again, it's like a one-page sort of narrative that says, this is where the person lived. They're on Medicaid, they're on SSI, this is their income, everything's going smoothly. And this is what happened. The individual had a medical procedure, whatever. It's just a narrative to the court to say that you're on top of everything. And then the guardian's plan is sort of how things are going to go for the next reporting period. And that is, we intend to have individual live in the same place, receive the same medical care, receive the same benefits. Here are our plans. There may be a plan to move to a different county or something like that. So that's the plan. So it's looking back and then looking forward. And that's the extent of reporting for guardian of the person.
Okay, so the trigger is because my 93-year-old mother passed away and then her children now become guardians of the sibling. That's what's initiating all this because we're not doing this reporting right now.
Well, to be honest, it's probably because I would say your deceased mother has been
She's
the
not
guardian for a long,
deceased yet,
long
I
time.
guess. Right,
Oh,
correct.
oh,
She's
okay.
always, she's still alive. I'm just saying.
Yeah, okay. And I will say for guardianships that were established many, many, many years ago,
Mhm.
Just because of the way that things work, they probably just, stop sending out notices to file these reporting requirements are relatively new in the past 10, 12 years.
Okay.
And so it's probably just a result of, an old file, everything's working fine. No news is good news type of thing. But now that there's a new guardian that's going to be appointed, they're going to be under the new rules. Yep.
Okay. Just like it would with because she goes, oh, I don't fill out anything for Social Security. I go, Mom, when you pass, that will change. Because
Right.
People. Okay. Thank you.
Yep.
Any more questions in the room or online? You guys did a wonderful job. And we appreciate you coming back each year and kind of just if we keep hearing it and keep hearing it, it starts to make more sense. So hopefully everybody's just taking advantage of this information and reaching out and asking more questions as they need to. So again, we appreciate it. Thank you, David. Thank you, Doug. Doug, we hope you feel better.
Thank you.
Thank you.
Okay.
Thank you very
All
much.
right. All right. Appreciate it.
Bye, everybody.
Have
Bye-bye.
a good night.